And now we have a panel discussion on ethics and GDPR in privacy-preserving data science. We will have Dave Buckley leading as moderator, and Carlo Salizzo, Konrad Kollnig, and Adrian Byrne will join him on stage. Dave Buckley is the Senior Technology Advisor at the Center of Data Ethics and Innovation UK, which enables trustworthy innovation in data and AI. Dave leads the work on privacy-enhancing technologies to support responsible data access, and he has spearheaded the creation of CDEI's Pets Adoption Guide. Dave.
Cool, let's get started. I feel like Phil Collins or something, wearing one of these microphones. Anyway, that's very much off topic. So yeah, welcome to this session. I can't claim that this will be the most important session of the day, as Christian's already taken that. I also can't claim it will be the most exciting, as June took that. It will be the final panel session of the day. So yeah, we're very close to the sort of refreshments and beer and wine that some of us may have already been partaking in. But yeah, so my name is Dave Buckley. As was said, I work for the UK Centre for Data Ethics and Innovation. I lead a lot of our work on what we call responsible data access. So this is a program of work that's really trying to sort of tackle that question of, there's lots of really useful, valuable data sets in the world. Most of them are siloed, very difficult to access for very legitimate reasons. What are some of the sort of methods, approaches, frameworks we can apply to be able to unlock the value of that data at the same time as preserving these really important sort of ethical principles around fairness, privacy, transparency, etc. And as you might imagine, sort of pets have become quite a big part of that work. So yeah, I've been doing quite a bit of work in that space, which sort of unexpectedly, I think Katerina basically profiled in her talk this morning, which is very generous. And I think I'm going to talk a bit more about that tomorrow. But yeah, for this session, everyone's favorite topic, ethics and GDPR. And yeah, I think this will hopefully build off a lot of the discussions we've been having already today around this kind of area, and hopefully get some really interesting and I think importantly diverse perspectives from the panel members, around these kind of issues. So without further ado, I might let you each first sort of introduce yourselves, maybe say a bit about what you do when you're kind of interested in this topic. Adrian, shall I come to you first?
Sure. Thanks, Dave. Yeah, can I be heard? Yeah? OK, great. So my name is Dr. Adrian Byrne. I'm a Marie Curie Research Fellow based here in Dublin. I'm between UCD CEDAR, which is the National Centre for Applied AI, and I also work with an SME in data analytics called Itero Analytics. And my approach to this topic is a bit different than what I've heard so far today, in the sense that I'm approaching privacy from tackling a different issue, which is complementary, and it's kind of a separate pillar, distinct pillar under trustworthy AI, which is fairness. And in my attempts to do that well and robustly, privacy has been brought to my attention. And so there seems to be some tension and trade-off in trying to determine what's fair and unbiased, and also being respectful of privacy for individuals. So that has led me to become an officer of statistics with the Central Statistics Office here in Ireland, to undertake a project for the next 12 months on looking at bias detection within the census microdata, and then injecting a pet. I'm going to adopt a pet, and then try to redo the exercise and compare the information loss. So I'm here as a kind of critical friend on the look for other friends in terms of being able to do this project successfully over the next 12 months, in order to be robust about describing fairly the tensions and trade-offs with trying to do bias detection, which is coming down the line. I know there's been talk of regulation today, a lot of regulation, and one that's particularly on my radar is the EU AI Act, which talks about bias detection and looking out for harmful and negative bias in AI systems. So my work is trying to future-proof in that area and provide advice and guidance on how we can be fair whilst also respecting privacy. And with that, I'll hand over to Konrad.
Thanks. I'm Konrad Kollnig. I've been actually interested in privacy for, as long as I can think, it seems. I remember being sort of 15, 16, ordering my first Raspberry Pi, invented in the UK, trying to make computing knowledge more accessible. And somehow my 15, 16-year-old really wanted to store his data on that device, building an own cloud instance, which would be a lovely idea if we could all sort of store data more decentralized. So actually, in our research group in Oxford, where I did my PhD, much later on, we've been working for a long time on personal data stores, Solist, together with Tim Berners-Lee and Nigel Shadbolt. That wasn't so much part of my work, though that's what motivated my work in privacy-enhancing technologies. I've been working quite a bit with the Open Data Institute on federated learning. We published a report in January this year because we thought, well, it's all nice and well that there's all this academic research going on into these things, but the translation into practice, making these things accessible, still remains a big challenge. So we published a report on, what is federated learning, how do you get started. And in my PhD, I've actually been looking a lot into GDPR apps. How is it implemented? How is privacy implemented in 2.5 million apps, iOS, Android, over time. And now I'm in Maastricht as an assistant professor at the law faculty. Yeah.
Right. Interesting that we've got sort of a teenage enthusiast for privacy and Adrian who claims to have privacy thrust upon him recently. There we go, a mix already. Carlo, come to you.
It calls to mind that Teddy Roosevelt quote, right? Some are born into privacy and others have privacy thrust upon them.
Exactly.
So hi everyone, my name's Carlo Salizzo. I'm a partner at Matheson LLP. We are one of the corporate law firms here, Ireland's largest law firm, I think is our new tagline. And I work in the space of advising my clients, whether they are technology companies, whether they are old-fashioned kind of goods and services companies, or any other companies in between, to comply with digital legislation, privacy legislation, including the GDPR, and whatever else the European Union wants to throw at us next. I started life as an IT outsourcing lawyer and evolved into a privacy lawyer in 2018, along with most of my colleagues. So I'm proud to be flying the flag for private practice lawyers here. I know I heard a sharp intake of breath when I mentioned that after all the slagging that we've been receiving throughout the day today. But hopefully I can share some of the value that that lawyers can bring to the equation.
I'm sure, and I promise well, from me at least, no slagging in this session. That's great, thanks for the introductions, everyone. So I wanted to kick off, given that we sort of have legal representatives and more kind of technologists, perhaps. I think one of the themes we've talked about quite a bit today is this, this idea that there's perhaps a problem due to sort of lack of alignment, lack of shared knowledge, a shared lexicon, shared understanding of these technologies when we're talking about them. Kind of wondering if you kind of agree that that is an issue that you find in your work when you're sort of talking about particularly GDPR compliance, but other regulatory regimes as well. So yeah, we'd kind of be interested in any thoughts on that from, perhaps start with you, Carlo, from kind of that legal perspective.
Yeah, I think to a lawyer, words have a very specific meaning in very specific context. And how do you know what that meaning is? You turn to the definition section of the law that you're reading and it will tell you. So the GDPR has a very lengthy one and it says processing means this and controller means that and anonymization means this, pseudonymization means that. So we know exactly what these words mean when we're talking to other lawyers. And then when we go and talk to somebody who's not a lawyer and we use these words and phrases, we don't always appreciate that they mean something different to different disciplines and different people. So, right, anonymization in shorthand is when you can't take a piece of information and reverse engineer it so that you can find out and identify someone to whom that information relates. Which may be a really simple definition for certain applications. It may not work in all cases. So I come across this on a daily basis. I use the word processing without even thinking about it. And when I use it, it means literally anything that you could do to data. Other people may hear that word and they think it has a very specific meaning. So I think kind of rather than trying to force people to use a lawyer's definition of things, which I think would be the inclination of many of my legal colleagues. I think we can all accept that that's not going to be happening anytime soon, and I think we can probably come into a more collaborative and shared vocabulary for these sorts of things.
Any thoughts from Adrian or Konrad to add? I think particularly around the anonymization point, I think that's one that I see come up a lot, and I think even today, where like, I've been at some of these sort of pets events before, where you always get asked like, oh, well, surely if I'm using these technologies, like, all the data's anonymous, so I can just do what I want, and I don't have to care about GDPR. And it even feels like in the event today, like there is no like sort of consensus. You know, if I'm homomorphically encrypting data, does that, like, to what extent does that kind of mitigate, you know, other things I might have to do to be compliant with GDPR? So yeah, kind of any thoughts on that would be interesting.
Well, it's partly the reason for the research I'm going to undertake with the CSO, and also anything I can learn here and with the audience members and with the panelists. You know, like when I'm trying to undertake a bias assessment, it's like in order to do bias assessment, we tend to want to take into account things that describe us as individuals, and these could be like the way that we group ourselves, or are grouped even if we don't want it. So like, you know, men and women, you know, white, non-white. These are terms that are used to describe us, and then so people can have a feeling of discrimination. How do we test whether someone has been discriminated against? How do we describe individuals? And then if we're going to do that robustly, how can we do that if we don't know who people are in relation to their characteristics because of anonymization, or that data has been distorted? I came across a paper last month that it talked about costs associated with deploying differential privacy in high-risk circumstances where the noise that you inject, and it's a classification task where subjects basically get a decision in their favor or not, that for edge cases that are close to the boundary of the threshold of whether they do or they don't, for the same level of accuracy every time you run the model with the differential privacy, certain individuals go in and out of being yes and no. And the paper is kind of suggesting that this is an issue to be discussed. So they're not saying that they have the solution, but they're just saying that there are issues with these solutions for privacy. There can be trade-offs that affect real individuals. And you might ask, well, who are the individuals that are close to the boundary of this decision? There could be some people that have very strong probability scores. They're way beyond the threshold. They're going to get the answer that they're looking for. But what about the edge cases? Is that evenly distributed across groups? How would we even know? So like, there's an issue around deploying this technology in certain circumstances that affect people's life choices and chances. And then on top of that, the even distribution around the fact that okay, we just accept there's a trade-off. Some people are going to be in, some people are going to be out. Is that randomly distributed, like amongst all of us? Or are some groups more affected by this than others when you deploy this technology? So does anybody have the answers to this? Because that's what I'm here for. It's not solvable. Okay, there we go. That's my starting point.
There we go. We'll try and solve it over drinks afterwards. I think that's the plan.
A lawyer would say, as long as you've taken reasonable steps, right, then you should be fine.
Exactly. And that's why we need you. Konrad, sorry.
I guess also there's a big question about what are the values we're seeking to protect. We've been talking a lot about privacy today. Not quite sure if we've even agreed on a definition of what privacy is. If you look at, say, the GDPR and the sort of first 3 paragraphs, that law says actually it's not a privacy law. It's aiming to do 2 things. First of all, protect fundamental rights and freedoms of citizens, including the right to data protection, which is not privacy, which is distinct in EU law, and also to enable the free flow of data, which again isn't privacy, right? You know, that's in conflict with privacy. Yeah, it just seems very challenging to formulate a sort of shared vision of what are those values we're seeking to protect. And you know, maybe by just minimizing it to privacy, we're making our lives a little bit too easy. You know, assuming agreement on those values, and you're saying, well, it's privacy we need to protect, but then everyone seems to understand something very different.
And I think that's at the heart of it, really, because privacy, as you say, doesn't exist in a vacuum. There are a lot of rights that we all have as citizens of Ireland, of the European Union, of the world. And privacy is one of those rights, but you equally have to balance it against the right to freedom of expression, the right to hold down a job, the right to start a business. And so if you are focusing solely on, right, how do I maximize privacy, then there's an ethical question as to whether you're doing the right thing at all.
Yeah, I think some really important points there. I think like the really obvious one, perhaps, well, it seems obvious, but probably hasn't explicitly been said today, is this idea of like, what is privacy? Most cases, right, it's a contextual thing, right? And we call them privacy-enhancing technologies. And I don't want to go down a rabbit hole of should we use this term or not. But I think, yeah, there is something about it. Like, it's not necessarily anything sort of inherently privacy-preserving if you were to use pets to, enable some kind of mass surveillance or something, for example. Some might argue that's not surveillance, but let's not go down that rabbit hole. But then I think, Adrian, another point that came to mind, you sort of talked about bias and discrimination. And I think this is another thing that we've seen a lot in our work, that sort of organizations are nervous about, say, collecting or accessing like demographic data because they think they're not allowed to do that because of GDPR. So then they have no way in which to actually assess whether their models or whatever other kind of data-driven tools they're building are biased, let alone mitigate it. Which, again, I guess also goes back to the point of context, right? Like, in many circumstances, it would be sort of legitimate to be able to access and collect that information so that you can do that monitoring so that then you can mitigate those biases and you could lead to better outcomes. But I guess there is this kind of, there's this perceived risk that that's problematic, but then there's also, potentially a trade-off between the privacy and utility of that demographic data. So that feels like, yeah, very much like an area where could pets like offer a solution to that so people don't have to take on that risk, perceived or not. And we can still do these things like mitigate things for the bias, which is a well-documented problem in like algorithmic systems.
Yeah. So the way I would say this, and I really appreciate the comment, Dave, is so in my line of work before privacy, it's fairness through awareness, which is something that was developing and gathering evidence on. And I think there's enough evidence now to challenge perceived wisdom that fairness through unawareness was fair enough. Like, so to your point, to not include sensitive attribute information, to be ignorant and blind of it, means that you're okay. So you take the data that you need for your model, you train your data, you run your model, deploy it, and you're good to go. And through experience now talking with people in industry, they will look me in the eye and say, I'm unbiased. I mean, I know I'm unbiased. I'm like, how do you know you're unbiased? Well, because we don't even look at that data. We don't collect it, we don't have it, don't store it. So how can you accuse us of being biased or even suggest it? They're offended. I say, prove it. How can you prove you're unbiased? And then they say, well, I don't get it. I say, how do you know that everything that you use is uncorrelated with the thing that you're not looking at? Okay, so this is where we get into the language of proxies, which is in the fairness, the AI fairness literature, and I think so. There is so we're having these conversations now, and the tide is turning. So fairness through awareness is coming through, and like for example, there's a law that's just come out in New York. This is the AEDT law. So this is the automated employment decision tool, New York City Law 144. I've had to make myself familiar with it. It's a bias audit, which basically, if you look at it, it's quite simple. They just need you to publish the sex and ethnicity of the candidates that were put through the AI tool in screening for employment decisions, right? But you need to know sex and ethnicity, right? So that's kind of pseudonymized, right? Because we're not using names and addresses. But we're finding through talking with businesses that they have names and addresses, but they don't have sex and ethnicity. So if we're going to get to a situation where we're deploying pets, that seems like it could be a viable way forward, which I'm investigating. The alternative, which is already in use in certain sections in the world, is predicting sex and gender from names. And I don't know what anybody has to think about, but I'd welcome to hear anybody's view on what they think about that line of endeavor, which is take your name and we're going to predict your sex and ethnicity from it, versus using a pet.
Well, I guess there's an interesting meta element, maybe probably to sum up some of the concerns you mentioned, that it seems like in the pursuit of privacy, we're actually facing the risk that we discriminate against some of the most vulnerable, even more than we already do. We might actually sort of reinforce those biases that we have. and only, I've mostly been studying federated learning, and when it comes to bias prevention in federated learning, the literature is actually not particularly advanced so far. That's a big gap. If you don't have the training data in a central location, mitigating bias is very difficult with these technologies. So again, what are the trade-offs? What are the values? What is privacy, and how are we protecting it? It's incredibly difficult.
Yeah, I think when you're talking about inferred data in particular, it becomes really difficult when it starts to present those edge cases you talked about, right? And when you get it, because you will get it wrong, right? 0.1% of the time, and suddenly you somebody whose name is Kieran, and suddenly an American system that doesn't recognize that name, predicts that is a woman from West Africa or something like that, and then for whatever reason that causes a suboptimal outcome for Kieran, on his J1. He might have then a legal claim against that company, right? He may feel that he's been discriminated against under New York law, and he's going to bring a lawsuit against that company, and he might win because they made up something that was not correct about him. And if you applied the GDPR to that scenario, that's the principle of accuracy, right? They've got inaccurate data about one person. So even in a world where you're talking about huge volumes of numbers of people, and it's a edge case, it's a corner case, it is a rounding error number of cases where this has happened. If it's caused a loss to one person, they might be able to come after you, and that's because their fundamental right has been overrun. So I think, I'm not saying whether that's, right or wrong from an ethical perspective or even from a legal perspective, but I think there is a question there as to whether you could or should do that kind of thing.
Can I just add to this? Because I know I spoke to Carlos before about the AI liability directive.
Oh, yeah.
Yeah. So you can say this better than me, but for the benefit of the audience about what's coming in terms of the burden of proof. So if, say, this Kieran brings a case in that jurisdiction in the EU for a discrimination, the burden of proof would be on the AI provider, or...
Yeah, so someone was talking...
How onerous is this going to be on people that are in the AI space?
Well, I suppose the caveat should be that the law has not been passed, it's not necessarily come into effect, but the gist of one of the provisions of the the Liability Directive, not the AI Act, is that where an AI system is involved in making a decision, right, if that decision leads to, say, discrimination, and you, as the operator of that AI system, can't prove that the AI was free of discrimination, then the court will presume that it was the AI that caused the discrimination. So traditionally in the law we think of causation, right? If you're the person bringing the claim, then it's on you to prove that the malicious act that you're complaining about caused the damage that you're looking for the compensation for, right? Very, very basic principle. But in the context of the AI liability directive, that gets reversed. So if you're defending the claim, you have to prove that the AI did not cause the harm that's being complained about. And as anybody who's spent even 5 minutes with an AI system can tell you, that is impossible to do. Because AI systems tend not to tell you why they've made a particular decision. I mean, I'm using a very particular definition. I think I'm really talking about machine learning here. But they tend not to tell you why they've made a given decision. And so unless you can build a system that does tell you that, I think if that law does come into effect, whether it's constitutional, I think, is another question. But it's potentially going to be really, really harmful to anybody who's trying to push the envelope in terms of AI. And I think the number one area in which we use AI at the moment is employment, right? Assessing CVs, deciding whether somebody gets a bonus, right? That's a really, really common time for businesses to use AI. And that is the highest risk, because that is where you're going to get discrimination claims.
But it seems like that seems very much doom and gloom, right? It seems like the approach is not a lawyer, but in my understanding, this approach is not unprecedented. In the current draft, it only applies to high-risk AI, which I think does cover some employment or unemployment.
All employment, yeah.
Okay, yeah.
Yeah.
But there it's a small category of AI, and maybe that's what we want.
Oh yeah, no,
right?
it's a small category of AI for sure, but it's a lot of people, and I think in terms of the use of AI, obviously it's a small corner of it, but in terms of the potential harm that might be involved, right? The potential for people to bring lawsuits. Everybody has a job, right? Every business has employees. There's a lot of potential liability there. So when you look at it from a financial perspective and from a risk management perspective, it's the sort of thing that can give you a headache if you have an exposure to everybody that you'd say, sorry, we haven't given you the job today. You know what I mean?
But then we use manual labor instead of AI. I don't see that necessarily as a problem.
Well, that's fine until you've got 300,000 applicants for the next role and you have to choose 10 of them. And you don't have the
use a
people to
robust
go through them.
methodology to do that, where you can prove that you don't discriminate.
Well, that's fantastic. It just means that you can't use AI to do it, which unfortunately is where we're headed. So I think at the end of the day, it just puts some roadblocks in the path. And I think there's challenges with that piece of legislation that are going to have to be solved if we're going to do it, because they do overturn something that's right at the heart of the legal system.
I'm going to bring us back slightly. I basically have one more question that I really want to ask, like, from my own perspective and from my own work, specifically on GDPR. I think there's this idea that, like, all this privacy-preserving data science, or eyes-off data science, sorry, is what I should be calling it, you know, that could represent quite a different, like, paradigm, a new paradigm of how you do data processing, where, you know, I remember, like, previous life sort of working in sort of organizations where, you know, as a developer, and I could just sort of, you know, had root access to everything, just download whatever data I want, play with it, do whatever, do my, you know, coding, data science analysis, whatever. But maybe we're going to move towards this more sort of zero trust world where we have sort of, pets enabling us to do data science in a different way where we can't see this data because of these sort of cryptographic tools, et cetera, that have been talked about a lot today. It seems to me like the GDPR was, you know, written in a world where this kind of paradigm didn't really exist, like wasn't really on the radar of people. And I'm wondering to what extent you think, you know, there may therefore be sort of legislative gaps in the regulation, perhaps. So, for instance, the example I always come back to is like, I don't believe at least that, you know, GDPR doesn't say anything about processing on encrypted data, which means then we get into these debates around, well, is encryption anonymous or pseudonymous? And then we don't seem to be able to come to an answer. My personal view, I think my personal view is that, like, it's because maybe the question isn't quite right. Like, you can encrypt data and it can be personal data under the hood, and that's still personal data. Like, that seems like a pretty valid argument. What I'm trying to get at, like, do you think there is a need kind of in legislation or perhaps just in more granular guidance that can, like, help people who are trying to use these sort of emerging technologies, like, really navigate what they can and can't do according to the regulation?
The good thing is I'm glad you haven't asked a controversial question. That would have been...
I can do if you want.
No, I'm kidding. Of course, you know, I don't think there's... If you ask anybody in the European Parliament whether they need to pass a new law, they'll say, absolutely yes, 100%, right? But I think, to be honest, as a practitioner here, that's a really simple question, right? Is the data identifiable, yes or no? If no, GDPR doesn't apply. If yes, the GDPR applies all the way, and you apply the principles, and you comply with Article 32, and you put your security measures in place, just as you would with anything else. If you want to get a nice data set that you can play with and do whatever you like with, well, we've heard from the recent decision about what Meta's been doing, that you need to get people's opt-in consent to use personal data for product improvement purposes. Okay, we can do that. We'll deal with that. That's fine. But I don't think it attacks the heart of the GDPR, because I think encryption is just seen as another security measure until it reaches the point that it de-identifies data, at which case we're outside the GDPR anyway.
Adrian or Konrad, any thoughts on this point?
I'm not quite sure if you need opt-in consent for product improvements. That wasn't my reading of that ruling. I think that was about pervasive online advertising. But in any case, I think, as has been highlighted today, the GDPR is meant to be technology neutral. You know, it doesn't seem to be hugely problematic in other areas to, you know, try to follow some of the rules. So as a company, I would probably assume that GDPR applies so as to be on the safe side, and that might add additional unnecessary costs. but from my perspective, the key challenges with GDPR are not so much on, how do we revise the principles, but how do we make these things work in practice? How do we do a better job at translating from the law into the technology? How do we give better guidance to technologies? And for example, if you look at, and I did that this morning for a little while, if you try to find the GitHub accounts of the leading data protection authorities, you find very few. I managed to find the GitHub account of the French Data Protection Authority, providing some sample code. But these things could be hugely helpful to say, and it doesn't have to be legally binding guidance, but to have some starting point as an engineer. How do I implement consent in code? How do I implement certain privacy-enhancing technologies in code? It seems to me as a technologist that this is still a long way to go in terms of providing that kind of guidance that really translates into code. Sadly, the reality seems to be, at least in the EU, that there's huge disagreement between data protection authorities. In January released a report on how consent should be implemented in code, in products. It's an 8-page report. The first half page of the report is disclosing sort of the limitations, that the authorities didn't agree, that you maybe should not follow that guidance, and it presents a minimum threshold for compliance. And again, it's a lengthy textual report. Maybe doesn't tell me so much as a technologist. What does that mean in terms of code? So I think that's an interesting road to explore. Just how can we marry law and tech better?
That's interesting. I hadn't really thought about that concept before, because I guess you have, this is how I'm seeing it in my head, is like you have the regulation, you sort of have the technologists, the people writing apps, writing code, etc. And there's always been this sort of gap between the two, right? And there's like a translation layer that has to happen, and time is needed to sort of develop the tooling and the guidance, etc. And it feels like, and as someone was saying earlier, I think GDPR hasn't been around that long, but I guess as time has gone on, as there's been more case law, more guidance has come out. So like now we have this, like the ICO's guidance on privacy enhancing technologies, but we could go a step further, right? And having GitHub accounts where the regulators give examples of how you might do this stuff in practice, and then I guess eventually we get to sort of standards, and from there it becomes much easier to be able to sort of, for people to be able to apply these things and have the confidence and the trust that what they're doing is going to be.
For example, until 2019, the European Commission provided sample code on how to implement consent in code. It was aimed at EU authorities. It wasn't aimed for the general public, but maybe that's still interesting to look into. But that's been discontinued, sadly. Because things suddenly got a little bit more complicated around consent, and I guess that's sort of where it's coming from.
I will turn to the audience for some questions in a moment. One final thing maybe I wanted to ask, and Konrad, this is aimed at you. I was kind of interested in the work you've done on sort of mobile apps in particular. I think sort of there are interesting examples. I think we talked about sort of federated learning examples. A lot of them have been sort of mobile phones where it's like Apple or Google, who are in the operating systems, are able to deploy federated learning for sort of predictive text and all that kind of stuff. Kind of just wondering for like general insights on your work in that space, because I think there's a particular idea that if I'm doing processing on the device, so I'm doing whatever it may be, that's private. And that's a claim people make. And I think we saw this with the Apple case, where they were doing sort of client-side scanning, or they proposed doing client-side scanning for sort of identifying abusive material, which they claimed to be privacy-preserving because it was on the device, or it was sort of in the iCloud at least. But then that sort of hit this backlash around, well, no, that's still kind of surveillance because you're scanning all our photos. Wouldn't call that privacy. Yeah, kind of wondering if any other insights from kind of the work you've done in that space, in like that mobile app sort of realm in particular.
Yeah, sure. So, lots of my work has been looking into sort of questions around privacy, platform power, and compliance. Been developing methodologies to study these aspects at scale. I think maybe taking a pet's perspective, as Jack mentioned in his sort of introduction, mobile operating systems have been a particularly fruitful playground for the development of federated learning techniques, because you can, scale training your models across millions of devices that are pretty similar, and train really, really competitive models. But maybe in the space, we also have a bit of a competition issue where it seems like that data is only available to certain companies, and even if these companies would open up data access, and we're seeing these things currently in the advertising ecosystem, where Google is trying to phase out third-party cookies, trying to roll out privacy-preserving techniques to replace that for advertisers to compete at that space, but still takes the lead on that, still sets standards. That it seems like we've got to be rather careful around how some technologies might allow, without many of us noticing, suddenly getting access to lots more data. And to give an example of that, on Android, if you use an Android phone, there's the privacy compute core that already processes lots of very sensitive data, like the text that you type, lots of device signals, sort of in a separate part of the Android ecosystem, and models get trained upon that and get sent to Google servers, sort of for as part of a federated learning process, some other pets. But that technology too isn't open to third-party vendors. So I think it's going to be hugely interesting. How do you build a competitive landscape around these privacy-enhancing technologies?
It's interesting. I know we've seen a few cases in the UK where, like, the ICO and the CMA, our Competition Markets Authority, have had to partner on these things, right? Because there are these super interesting trade-offs between privacy and competition. Seeing that all play out is fascinating.
Dave, can I just make one?
Yeah, please do, Adrian.
GDPR, because I find it's been reinvigorated for me with the suite of legislation that's coming. And has already started to come with the Digital Markets Act and in the Digital Service Act and in the Artificial Intelligence Act, all in the EU. Not for the UK, but we'll park that. But essentially, if I just make one bold claim, so Article 15 in GDPR, I think it's 1 part H, is the right of the individual to know that AI is being used in the process when they submit their data. It's just a raising an awareness thing. And this idea of the GDPR is where, okay, we impart our data, there's for service. So we have to give of our data to get a service, okay? The GDPR can provide trust in relation to that one act. But the interesting thing for me coming down the tracks here with the AI Act is that not just giving of the data, but then automating, using that data in an automated process to infer a decision on individuals is going to tie that, I'm making this bold claim, to Article 10, Part 5 of the AI Act, which is to do with bias detection. So it's reinvigorating existing legislation with legislation that's coming. And I'm saying to myself, watch this space.
That's great. I feel like we've covered a lot of interesting things around this general space of GDPR, ethics, etc., that we could probably talk about for hours. We do have a couple of minutes, so if there's any questions, we can probably squeeze in 1 or 2, if there are any takers. June.
Controversial as possible, please.
I've been told to stand up. Great. So I don't know the GDPR to the level of detail as the people on stage will, so apologies if this is kind of a naive question, and it might verge a little too closely to what Dave was asking about homomorphic encryption. But as far as I know, under the GDPR, the data controller has the same responsibilities whether or not they have sight of the data, right? And I'm wondering if that complicates this idea of eyes-off data. And the responsibility that might entail. Is it indeed a kind of, is it offering something new when it comes to the law?
So I think the really helpful thing about applying encryption or any security measure is that it's going to minimize the risk that anything that goes wrong is going to cause harm to an individual. Because at the end of the day, that's what we all want to avoid. And there are some things baked into the GDPR that will give you automatic credit for that. So for example, if there's been a data breach, but the only data you've lost is heavily encrypted, then you don't have to notify data subjects, because if it would be impossible to reverse that encryption, given the state of the art. So while yes, basically the answer to your question is you will always be responsible for your data so long as it remains personal data, the real advantage is the ability to have that massive additional layer of security, and in an ideal world, right, and perhaps a theoretical world, mean that it's no longer identifiable and it's no longer personal data. But that's a bigger question.
And we're about to reach 0 on the timer, so perfectly timed. And I don't know how I would have summed up that conversation, and unfortunately I've run out of time. But it was super engaging and lots of food for thought. So thanks again to all the panelists, and thank you guys for listening.
Thanks, Dave.
Yeah.